Do you think life is simpler as time evolves? For some, it can be more complicated when facing issues about health, estate plans, probate, long-term care, and more. That's why Attorney-CPA Joe Cordell hosts ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Here's Attorney-CPA Joe Cordell.
Welcome to another episode of ElderTalk. This week we're going to be talking about how you plan for the balance of your life and beyond. And we're going to try to make this simple. We want to approach it as sort of the three most important to-do items that should be on anybody's list as they reach what I might call the last third of their life. And we're going to break this into two parts. And we have with us this week a guest that you're likely to hear from in the future. Jill, do you want to introduce our guest?
I would be delighted to. Jessica Jax, she's the managing attorney with TuckerAllen. Thank you for joining us. And understand there was a merger that just happened recently between Cordell Planning Partners and TuckerAllen.
Yeah, there has been a transition. I will talk first about that, Jessica. Then I'm curious to get your thoughts because Jessica is on the ground. I mean, she's the one who's actually practicing every day and managing more the two teams. And I kind of sit a little bit above that, so I'm not fully informed as to the details of how these things happen. But I can tell you that it's very exciting. We recognize that TuckerAllen, which is a firm some people are familiar with in St. Louis, hopefully a lot of people, they have a marvelous reputation in estate planning. They did less elder law and a lot of estate planning. And as people who listen to this show know, elder law is kind of the focus on really positioning your assets to pay for long-term care. That's
right.
Kind of the primary focus, among other things. So the great thing about TuckerAllen is that they had a marvelous team of attorneys, a marvelous reputation, and Jessica had headed that team for some time. So it seemed to us at Cordell Planning Partners that this would be a marvelous combination. And so we approached TuckerAllen. Ultimately, a deal was done. And Jessica has ascended now to the position of being managing attorney over all the attorneys at what is now TuckerAllen. We decided to keep the name TuckerAllen, Jessica, because we thought that it was more established and had a wonderful reputation. So we thought it was better to jettison the Cordell Planning Partners and go with TuckerAllen.
Sounds like it's been a great fit.
Absolutely. We are so excited for the merger and really having such a breadth of services that we can offer to our clients now and really be able to help people throughout the entire spectrum of their lives. Younger people definitely should be thinking about estate planning, new kids, first house, that kind of thing. But we didn't like that once people did get to that last third of their life that we were not as able to get them the services that they may have needed. And so with this merger, it really just lets us be an excellent partner for our clients throughout their lives.
So it offers an expansion of your services.
Absolutely.
Yeah, it is. It's a synergy, right? I mean, it's taking a firm that focused on people over 65 really exclusively. That's what Cordell Planning Partners was. And now it's combined with a firm that reaches down and focuses on estate planning with people in their, of course, you accept people 20s and 30s, but I think the sweet spot for TuckerAllen was more late 30s, 40s, maybe 50s. So we recognize that that's a tremendous opportunity for growth, a tremendous area of need. And quite frankly, to the extent that you reach people a little earlier in their planning, it often makes it easier on them when they do get the stage of life that Cordell Planning Partners was focusing on. So, of course, this show's called ElderTalk. So, we continue to focus on elderly, but Jessica really brings a wonderful perspective to this discussion. We're excited to have her in this role. And so we thought that this week would be a wonderful time to sort of talk about what are, again, the sort of top three to-do items that people should think about as they're aging, and especially as they hit that 60 mark. So, Jessica, what would you identify as perhaps number one on your list?
I think number one is unquestionably having effective powers of attorney in place. Yeah. Assets aside, if you have those powers of attorney, you're worried about who's making your decisions for you, and that's your lifetime we're worried about.
And that's huge.
Yes,
and it can happen
absolutely.
so fast.
Absolutely,
you can be going to dinner one night, and suddenly there's a stroke
right.
or a heart attack, and and the person is immediately out of control of their lives.
Mm-hmm. And they want their loved ones, their chosen ones, to be the ones who can make those calls and not just whoever might happen to show up.
Yeah.
Would you recommend more than one person in that role?
It really, in my opinion, depends on the family dynamics. I've worked with families who would not put more than one person in that role because they've got their one person who is the obvious choice.
And some don't even have the one person.
Some don't have the one person. And then I have other families who it makes sense based on their family dynamic. The kids get along, they want to make sure that everybody's involved, or maybe the kids don't get along and they don't want one to be able to run and make decisions without them. So it's very family dependent.
Now, what about someone that doesn't have children or other family members that they would trust in this position? Would you recommend then just a close friend?
I always tell my clients, you pick the best person for the job, and the fact that they're related by blood isn't necessarily consequential to who you might choose. There are exceptions to this, but most people have loved ones, whether that's children or grandchildren, nieces or nephews. It could be a neighbor or a friend, or any individual can help them in that role if they have that type of close relationship.
Yeah, and character's huge, isn't it? Almost
Absolutely.
more than expertise. It's really character that...
Absolutely. Well, it's you're entrusting another person to make huge life-altering decisions for you.
When by definition, you're incapable of monitoring it.
Yep. And so you need to feel good when you sign a document to know, hey, the person I'm putting here, they always are going to have my best interest at heart,
Right.
and not their own, or let somebody get in their ear that you might not want there.
Now, contrast for us the difference between, on the one hand, the power of attorney, which is kind of a simple, free-flowing sort of document, versus something that's more structured, like and still I'll try to stay out of court, like, for example, a trustee of an irrevocable trust, or a trust that was revocable and became irrevocable. In other words, talk a little bit about the alternatives for people who may feel less comfortable with something such as a simple power of attorney.
Right. So like you're saying, the power of attorney, in most cases, is really giving an individual that you name the authority to sign things you can sign. So it's big, and it's a broad authority that is given to someone. And a lot of people, it does give them heartburn, makes them nervous. So there are alternatives like putting assets into an irrevocable trust and putting someone else in charge of it. That way you can limit how the money is used, who it's used for, how much money you put in there, what exactly the assets are. So it can create a little bit more structure around what you're handing over to another person.
Now, with power of attorney, does that mean they also make medical decisions?
So typically you would do two powers of attorney. You would do a power of attorney for finances or property, and you would do a power of attorney for healthcare. So it kind of breaks up those two jobs. Essentially is the same type of appointment. You say, this person can make those decisions in this realm for me. But people don't always necessarily want the same people in those roles.
Yeah.
And
I can see that,
I
sure.
mean, they're different skill sets, and the individuals who you may absolutely want to pay your bills for you or be able to write a check out of your account are maybe not the ones that you would trust to decide, to make an end-of-life decision, for instance.
And more nurturing decisions,
Yes.
too. Yeah.
Mm-hmm.
Yeah, I often use my daughters as examples of this. I'm glad they're not listening to this show. But they're now in graduate school. But I have one who, she's just very focused in all business. She's the one who would make wonderful decisions financially, et cetera. She's in law school, incidentally. And then the other, appropriately enough, is in medical school. But apart from that, she's really, by her nature, she's more nurturing. She's somebody
More
who...
compassionate.
Yeah, she's going to think more about somebody's feelings and how things are going to impact them. And to some extent, my other daughter, who has many good qualities, but that's not, her brain works differently. So I think you're right. I think people have children who perhaps are better in different areas of their care.
I would say it's almost more common than not that clients I work with name one, with multiple children, they name one child in the financial roles and a different child in the healthcare roles.
Yeah. I guess that is probably more common than not. So let's talk about kind of the next step on the extreme. If we imagine this continuum, On the looser end, the less formal end, you have the power of attorney, which is kind of this grand blank check, we'll call it. More than a blank check because it covers things that aren't in checking accounts.
Right.
And then in the middle, this thing where you can create rules like you described through trust. And then finally, on the other end, I guess the most the least desirable and the most governed through government or other officials would be where you get a conservatorship and guardianship declared. Can you talk just briefly about what those two things are?
Absolutely. The conservator and guardianship, conservator would cover finances, guardianship covers the person. And kind of what it is the court appointing someone like you would appoint in a power of attorney. And typically when it comes up is when, like you mentioned before, if someone does have a stroke and they didn't have those documents in place, you can't put those documents in place if you no longer have the capacity to do so. And so it's the court process by which the court appoints someone on your behalf. So it's a good process to have in case you need it, but it certainly is not ideal.
So it's not ideal, yeah.
Who does the court appoint? Someone that, this individual knows, a family member? How does that work? What does that look like?
Typically, a loved one would petition to be named in that role.
Okay.
Is how it would most commonly come up.
And it could be a fight if you had a disagreement among the kids over who's going to control the money, especially. And it's funny, it's probably more common to have the fight over the conservatorship side, which refers to the assets, versus the guardianship side, except in the states where they're one and the same.
Right.
Missouri has two different positions. But you're a little kinder to the process than I sometimes am. But I think that you said it well because it does serve a very valuable purpose. I'm often quick to point out that it does mean, though, money's being spent from the estate. It does mean that lawyers are hired. A doctor's probably going to do some sort of evaluation. It means that there's delay and expense. So I'm emphatic that people probably would regard that as their worst case scenario and not their preferred.
Absolutely. In my mind, the guardianship and conservatorship are what happen to make sure your loved ones can take care of you if you didn't plan early enough.
If you didn't have power of attorney.
Correct. Exactly.
But it's good to know that for the people who do nothing, then there is something in place to provide for their care. But our goal as lawyers is to try to have them avoid that.
Absolutely.
Right, to be proactive. Absolutely. So the guardianship, that's the person that actually physically takes care of.
It's the guardianship covers the person, so they would be responsible for things like making sure that meals were taken care of and hygiene was taken care of, things like that.
Doctor's
where they might
appointments.
stay.
Yeah, exactly. And the conservator handles the finances pieces.
Yeah. So I guess then it would fall on that the conservator might resist, for example, a recommendation by a guardian where the guardian is saying, I want my ward, it's called a ward, I want my ward to be placed in a certain long-term care facility, and maybe it's like $10,000, $12,000 a month or more. Maybe the conservator thinks that's too much, and that's an example where you would have these two in front of the judge and the judge deciding. But unless there is that problem financially, then the conservator is going to dispense the money as the guardian is recommending regarding those care items.
Right.
So you do want different people in those two roles, in my opinion.
I would think so. And with probate court, that is something you don't want.
Explain that. Explain that, Jessica.
There's challenges with that.
Well, here we're going to come to probate in a minute, but this is called probate, right? When we talk about guardianship, conservatorship.
Probate court handles it, absolutely.
Oh, it is? Okay.
So it's not just wills that probate handles, it's also these actions, the same court.
I did not realize that.
Yeah, same court handles those things. Probate is, I kind of think of it as a necessary evil. It has to exist so that guardians can be appointed when needed, conservators can be appointed, assets can get transferred when people didn't plan. But such minimal planning on the front end can bypass the need for all of it and make the person's life easier, make their family's life easier, and really make it far more likely that their wishes are going to be handled in the way that they would want.
And so let's move on to the next couple of items on our list. So number one on your list is a power of attorney. That's typically the simplest remedy to take care of us when we're alive and incompetent. What about item 2?
So I would say the second thing that people should really think about as they age is how they're going to finance their care as they get older. I think as most people know, that care can get very expensive very quickly, and
especially healthcare.
Especially healthcare. And I think there are various options that people can use to be mindful of what's coming and plan for it and have the resources necessary, or get on programs that will help them. But you should think about it earlier rather than later to keep your options open.
Yeah, because the good news is that often with planning, people can qualify for Medicaid and still be able to keep a lot of their assets. And for everybody, it's different, depending on what's in their portfolios, what their assets are comprised of. Is it more real estate? Is it more 401k? What is it? But for the most part, if people plan, they can still qualify to get Medicaid. And just think about that. That's a cost that can easily run $10,000 a month indefinitely. And we don't know which of us will be paying that amount of money and which won't. Now, some will see smoke on the horizon. They'll have indications in advance, whether it's Parkinson's disease or some diagnosis, where they have reason to expect that they may be needing long-term care for a substantial time. So in those cases, it is a matter of thinking, how do you want to pay for it? Do you just want to use your assets? Talk a little bit about the options.
So in my mind, there are basically 3 options. There's you use your assets. You private pay for whatever care you might need, and you either have money left to pass to your family or not, but you private pay with your own funds. Option 2 would be to get long-term care insurance so that you have a little bit of coverage if you do need care. Being mindful of what's the actual coverage look like, because those policies vary widely.
And can you qualify?
Or does it make sense to pay for it, depending, it gets obviously far more expensive the older you apply for it. And then the third option is using a service like Medicaid that it can cover those costs. But like you said, the planning has to be done ahead of time to make sure you're going to qualify.
Well, with Medicaid, you're only allowed a certain amount of assets. Is that correct?
Absolutely.
So how do you plan? What do you do with your assets in order to qualify? Can you paint a picture of that?
Well, we need to answer that the way it should be answered, Jill. We need a couple of shows, which we've done. No, it's a good point you raised, because there are people out there who are on the edge of their seat wanting to hear the details. And I'll say this: we've done shows like that in the past, and we'll do shows in the future like that. Just to give a kind of an overview of an answer, then I'll let Jessica tag into this, is depending on what the assets are, some things you can transfer into an irrevocable trust. That's kind of for many such plans, that's often the centerpiece. It doesn't have to be, but often there will be certain assets that people will put into an irrevocable trust that will have certain rules. So the person's agreeing that, look, in exchange for my not having to regard this asset as mine for Medicaid purposes, I need to create a trust in which there are rules in which I can't reach in and use it for anything I want. I can have, for example, the income from it. I can probably have say over how it's managed. I can probably even have say over if the money's given away to third parties. But I can't reach in and use it to go on a vacation like I could before.
Okay.
So that's one example. Another is that you can decide that you're going to perhaps put more loans on an existing house or on real estate that, for example, you might have that would otherwise have qualified against you. You can make certain gifts of assets. There are some types of transfers that won't work against you, depending on if somebody in your family has helped take care of you. For example, there are circumstances where you can have a sibling on your house and it won't be counted against you, or a child that has lived with you and helped take care of you. Your house may not be counted.
I've heard that one.
Yes.
Right. If there's a child, like even an adult child that has taken care of you.
And it normally is it's an adult. It's called the child caregiver rule. So there are kind of a toolbox of things. But that's what you're doing. You're trying to move the assets in such a way that you conform with the rules of Medicaid. It's nothing underhanded. It's nothing in which you're trying to deceive or conceal. Instead, you're using the rules themselves to allow yourself to qualify and still have, whether it's $500,000, some people $1 million that they've worked their entire lives to save, and they had plans for it benefiting their children and grandchildren, and they just don't want to see that money eaten up to pay for something that they think they've paid enough taxes for over the course of their working career. They feel that they should be able to qualify for that and still be able to transfer those assets to their loved ones.
I completely agree with that. I think the thing people should know sooner rather than later is that there are a variety of strategies that can be used to pass some or all of your assets onto your loved ones when you're gone and still receive Medicaid to cover long-term care while someone is living. Like you said, the best strategy is super dependent on the family situation, what the assets are, who's taking care of people, what your kids are doing, how they are. And so there's not a one-size-fits-all, here's what you do. It's you look at the situation and use the strategies that are available that are best suited for a family. Yeah,
it is very case-specific. If we meet with three people in a row on a given morning at our offices and all are wanting to do some form of Medicaid planning, those plans are likely to look very different for all three of them based on the fact that our lives are different. One thing let me mention, though, that is very important, too, in determining which particular approach we'd take is whether somebody is okay on a 5-year look back. Many of our listeners have heard of this rule that when you make a transfer, Medicaid has said, well, we'll go back 60 months and count anything you've done, anything you've given away. We're going to pull that in and consider that as one of your assets today. So people who don't have a diagnosis, who are in relatively good health, say you're 70 years old, you by all appearances, but to your knowledge, you're in fine health, but you know that's not going to always be true. And for people like that, where there's not a sand going through an hourglass that they can see, in other words, a diagnosis where maybe they have an Alzheimer's diagnosis, or choose your example. For those people, they have a lot more options because they don't mind the 5-year look back. They're willing to assume that risk. So under those conditions, you can transfer anything to anybody, and we discourage just transferring assets to people. That can be there's many, many reasons to not do that. Let me hurry to tell people. But anyway, you can transfer to an entity like a trust, which is safe to transfer versus your brother-in-law. Nothing against your brother-in-laws, but the whole idea is to put your money in a place where it's still safe, and there are rules in place, rules you created. But if you don't mind that 5-year sort of penalty period, for lack of a better word, then lots of things are open to you. It's just one of those reasons it makes so much sense to plan when you're healthy versus when coming in when there's been some diagnosis. And I would, what did you say, Jessica? Maybe 50-50, maybe half of the people that come in with long-term care planning issues, maybe half are people who are there because something's come up. There's been a diagnosis or something.
I would say it's at least half. I think people often don't think about it until there is a diagnosis facing them, which is unfortunate because they don't have nearly as many options at that point.
Yeah. It limits the options, and thankfully it doesn't eradicate them, but it limits your options. Some of the best stuff you can do, you probably wouldn't do in that case. You'd use different approaches.
Well, I have a question. Okay, say someone during this month of February goes and sees an attorney and creates this strategy to qualify for Medicaid someday, and they're thinking it's going to be way down the road. Well, then say in April they have a stroke, they become incompetent. Is that enough time, for them to qualify for Medicaid, even though 2 months before is when they created that plan?
Well, from the moment they apply for Medicaid, they're going to look at that period of time. So that's one of those cases where you'd be looking at the 60-month period, and you'd have to be doing other things. And there are some other things you can do. You can do a spend down, spend money in ways that don't create additional assets but still give you some benefit with what you spend it on. You can transfer some assets from assets that are counted to assets that aren't counted. but it's a short list of things that aren't counted. You can choose to focus more on the home, which is a temporary refuge, versus other assets. Many people believe that because a house is said to be exempt, that means that it truly is exempt in the way we would usually use that word in the English language. But the way that it's used for Medicaid purposes is it's exempt while you're alive or until you leave the house with no reasonable expectation of returning. Now, if you have a spouse living there, then it will be postponed. But the point is, someone someday, and as soon as the Medicaid can do it, is going to be knocking on the door saying, we want to be paid, and we're selling the house to get paid for all the benefits that you derive through your Medicaid. So that day is going to come. It may come the day that you leave the house to go into long-term care. It could, if you have no reasonable expectation of returning, and that's kind of a little bit of a fluid phrase. And it may be postponed if you have someone living there. But the day of reckoning is going to come. That house is not going to make it to your loved ones, as you might hope, that equity for their benefit when you pass. That's not going to happen unless you plan for it. And there are ways to take a house that is, quote unquote, exempt in the limited way that I meant and move it into a trust where it's fully exempt in the meaningful sense of the word. There wouldn't be any day in which you would have to repay that money from that house.
Don't they have only so many years to do that, Medicaid, after the person has passed away?
Well, not as I recall from the statute. It's a debt, and it might be captured under the general limitations of debt collection, which apply to all of us, meaning someone cannot tag you 30 years later on a debt that you had. And I don't know what that statute is, but I can tell you in Missouri, it's required that there be collection efforts. It's called asset recovery. By statute, the Attorney General's office will pursue a collection claim for any benefits, the total dollar amount that a loved one received from their estate. So it's not just that they can do the house, they can do any assets that are in the estate that are available, but the house itself becomes available at the point that after you've passed away. Now, there can be exception to that where a spouse continues to live there after you've died. Mm-hmm. So there are some limitations. But at one time, we were thinking that, well, look, they lose track of it. And there was that. That was an administrative thing, not a legal thing.
Right.
They would lose track of the house. So you have this surviving spouse who may live there for 10 years or so, and somehow they didn't show up at the surviving spouse's now dead estate. So that happened more commonly a few years ago. Now the processes are getting a little more efficient. The federal government is becoming more insistent that states not blow off these repayment opportunities, which for a long time they did. This has been on the books for many years. It's not a new law. Asset recovery is supposed to be being done for the last 20, 30 years, but it wasn't so much. And now attorney generals are very vigorous in doing it because I can tell you that CMS has made clear that if any state blows off its responsibilities to recover these assets, then the state can become disqualified from any reimbursement for costs for Medicaid.
So that's a good motivator.
So it's a big motivator for the states. Plus, the states get half the money that they collect.
Can I add one thing to our discussion about gifting those assets away that I think I hear misconceptions about a lot?
Yeah.
People seem to think that I can give $15,000 away a year and not have any, Medicaid won't care. But that $15,000, they call the annual exclusion, and that is a completely separate question from qualifying for Medicaid. And so people need to know that they can't just be passing out $15,000 checks to their kids and grandkids and then apply for Medicaid. Medicaid cares about those, even though the IRS might not care.
Yeah, that's good you mentioned that because it is a common misconception out there because everyone's heard, I can give away $15,000. And that's a whole different set of federal rules. That's the IRS.
Right.
We're not dealing with the IRS here. The enemy we're trying to dodge is the Medicaid rules. So, there is no permissible gift amount for purposes of counting Medicaid. If you've been given $15,000 a year away, then for the past 5 years that would be counted.
So definitely something you don't want to do.
Don't want to do. So let's do this. Let's take a quick break. We'll come back, and we have time for the third item on Jessica's list of most important things to do as we plan and age. Back in a moment, another episode of ElderTalk.
You're listening to ElderTalk with TuckerAllen, providing intelligent answers for those thinking about their future. Sponsored by TuckerAllen, your estate and elder law advisors. And now, Attorney-CPA Joe Cordell.
Okay, we're back with ElderTalk. And with us is
Jessica Jax, the managing attorney with TuckerAllen.
TuckerAllen. And so it's appropriate that we have somebody from TuckerAllen on, considering that they sponsor this show and play an important role with this show. And I think that Jessica's bringing a perspective that's a little different from what we've often heard in the past, which is just focused on what we've called elder law. So her focus has been primarily estate planning and less on the elder law piece.
Right.
So it's a great complement to kind of the focus that we've often had in the past. So let's continue with your list, Jessica. This is not mine. This is yours, which is a great list. To item number 3 of the 3 things that we think are most important for people to do in their planning as they age.
So I would say number 3 is what I've called asset planning. And it's a broad idea because it could cover a lot of different things. And it ties into our number 2 of financing that long-term care. But when I say asset planning, I mean, how are your assets going to be used both during that latter part of your life and also what's going to happen to them after you're gone? So asset planning could mean passing assets into an irrevocable trust so that you can qualify for Medicaid and then specifying what will happen to those after you're gone. It could mean just making a decision, I'm going to use these assets to the extent that I need them, but where do I want them to go? Who should receive them? Under what terms should they be received? So it's really thinking about that nest egg that people have amassed over the course of their life, and over the next period of their life and after they're gone, what do they want those assets to be used for, and who do they want to benefit from them?
Yeah. It's kind of like people deciding, am I prepared to use these assets myself for the balance of my life? Mm-hmm. Or do I want to do everything possible to preserve these assets for my children or grandchildren? And there's a little bit of a fork in the road there, because sometimes to proper care during the course of your lifetime, depending on the extent to which Medicaid planning is available, and not everybody can choose to plan in such a way that they preserve all their assets. So sometimes it is a fork in the road saying, I'm prepared to really cut back on my care. I'm prepared to do everything I can, squeeze nickels and everything I can to preserve my assets for my children or my grandchildren or somebody else for when you pass. And others have the total opposite view. And I have those clients who come in, Jessica, we've had this.
Yes, absolutely.
Clients who come in and say, look, I'm concerned about what happens with my stuff when I'm gone, but that's not my primary concern.
Right. Got to take care of me right now.
Yeah.
Exactly.
My primary concern is assuring that I have proper care for the balance of my life, that I'm comfortable. And often these people aren't selfish. Sometimes they don't have children. We're just talking about nieces and nephews. So sometimes there is no one that's real close to them. But for others, it is kind of a set of values where they feel that their loved ones should not expect to receive anything from them. Maybe they didn't receive anything from their parents. Mm-hmm. So it is something that's almost philosophical that varies from one client to the next.
And I think it's important to note that if you plan early, you can also create kind of a melding of those two ideas and say, you know what, there are certain assets that are very important for me to get to my family. The family farm, the vacation home, things that have a sentimental value.
Like a family heirloom.
Really, we're thinking more bigger items typically, like a family farm or a, great-grandma's house or something that's been in the family for a long time. And they want to be certain that continues to pass in their family and they don't need to liquidate that asset to pay for their care. But they may be perfectly happy to liquidate their 401k that has no sentimental value.
Right.
So if you do the planning ahead of time, you can say, I'm willing to use everything except grandma's house to pay for my care. And let's plan accordingly.
Yeah, it is not simply the two choices that I talked about. It can be so many variations. And there are some people who do have heirlooms, and real estate often they regard as that.
Sure.
That, that trumps everything sometimes. So this makes number 3 on the list for the reason that we think that, number 1, I guess you chose to have some sort of power of attorney or some mechanism to kick in. That's above the estate planning, just because if you don't have anything in place for your care for the balance of your life, then whatever your plan was, that could go awry. Right?
Absolutely. And I view it as, when I have a client that comes in, their life is the most important thing. So what's their life going to look like? And to the extent we can preserve assets to get to the next generation or their loved ones, that's great. But first and foremost, I care about their life and what that's going to look like.
The here and now.
Right.
Yeah, and one thing I'll mention is, and this is a good thing, is that the power of attorney, if it has the rules prescribed by the state of Missouri, then you cannot give that person, nor can that person extract from you, the authority to make changes to a will. However, there can be in your document, and those of you who think you have a power of attorney in place that you want, I suggest you pull it out and look at it, because it might be that the lawyer you had draft this, or the website, heaven forbid, from which you ordered this, might have taken the view called the kitchen sink approach, where they assume that somebody who gets a power of attorney, they want the person to have power over everything, and the broader the better. So that's often the plain vanilla form that people have, and no one discussed with them the fact that, yes, it is true you want someone to make certain decisions, but by no means does that mean that you want people to have carte blanche over everything, including your estate planning.
Right.
Because often these people have a conflict of interest, and estate planning is something you want to nail down. For example, what Jessica was just saying, you want to have in place those very fundamental criteria about taking care of your grandchildren or that house that's an heirloom. I mean, those things you don't want tampered with. But if you give somebody this super blank check, then they can tamper with everything. Now, again, under Missouri law, you have to specifically give them authority to make changes to your trust, to transfer assets in or out of your trust. So check the documents. Those of you listening, check the documents at home. See if you've given that authority to someone, then ask yourself, do you really want to do that?
So it sounds like it's important that you define their authority and what their responsibilities are.
Absolutely know what authority you've given. I think in many cases you do want that agent to have fairly broad authority, though I would stop short of giving someone the authority to change my estate plan in most instances, because you do usually want that set before you're unable to make those changes.
Yeah, there are, some people would say, I'm going to be devil's advocate here. Some people say when there's very complex estate and tax planning, for example, there'll be lawyers and CPAs who will say, well, we need to be able to reach in and make some changes because the tax law may change. Other things might come down the pike. And I get that. And I'm a CPA and a lawyer, so I understand that argument. But let me tell you that you may decide that there are some things you want to nail down and that you're prepared to live with any adverse tax consequences or whatnot that might come down the pike. And whenever you're going to surrender your ability to make those changes, you may decide you don't want someone else to make them. And you may be perfectly comfortable with saying, I get it. There may be reasons that somebody could legitimately want to reach in and change my plan. But you may want to know that whatever happens to you, if you have a heart attack or a stroke today and you become incompetent, you may want to know that the fundamentals of your plan are not going to ever be tampered with. And I think most people feel that way. And most people, incidentally, don't have these esoteric problems I just described. This is the 1%.
Right,
Yes.
right.
I think it's just most important that people know what's in there, because I agree. Most people don't have those problems. But I also think, particularly if you bought a document off the internet, you don't have an understanding of what's in there, but you could be signing away huge authority to someone without even really
Always
realizing
good to
it.
consult an attorney. I mean, yes, going on the internet, it makes it convenient, but like you said, you may not understand everything with that document, and you have to be very careful.
Yeah,
Absolutely.
and let me clarify something. Just to make clear, the state of Missouri will not allow you under any conditions to give a power of attorney the authority to change your will. But it's your trust that's at risk. You can give that authority, but not your will. And your will becomes moot if you've decided that you're determined to avoid probate. A lot of people choose to do their estate planning with a trust because they want to avoid probate. And if that's what's happened, then this law that's intended to protect, those sacred things because you can't tamper with a will, wills to people who plan are a little obsolete.
Absolutely, they are.
Because they're more vulnerable to legal challenges? Is that why?
Because if you've done your planning right, the will won't govern any assets. If you've done your planning right and have all of your assets into a trust or directed to a trust via beneficiary designations or directed to loved ones via beneficiary designations, the will won't govern any assets at all. So it really loses authority. Ideally, if you've done your planning right, your will won't do anything.
It's kind of a safety net down
Absolutely.
there.
Right.
Yeah. If there are assets floating around that you didn't know about and you didn't direct to your trust, then you know that net's out there. But yeah, as Jessica said, it's not intended to be used. You're supposed to get everything in your trust. So it does mean that the action is going to be with your trust, and you have to make a decision, and a very important decision, about whether you want your power of attorney to give someone who may be in control of your assets in fairness. Let's imagine a scenario with technology, medical technology, pharmacology being what it is today, that you could be in a state for, heaven forbid, for any of us, for 30 years in which somebody is managing your life
Right.
through this document. So if that's the case, you have to ask yourself, do you want them to have some control of this trust? And of course, I made the argument a while ago why you wouldn't, but I don't want to be too heavy-handed with an opinion on that because I know there are people who would say, look, I do know that over that period of time, I'd want them to be able to make changes to the trust. So the nice thing about, as you said a while ago, Jessica, the nice thing about this power of attorney is that you can customize it. Mm-hmm. You can say, okay, you can do this with the trust, but you can't do that. So you can draw boundaries.
Draw boundaries around things like making changes as a result of changes in the law, but maybe not changes to who the beneficiaries would be.
Now, what type of individual would a will be best suited for, where the person just has a will?
A will is really most appropriate when the assets are very simple and the distribution is very simple and there are no minors. So if you have a client who is a single woman and or a man for that matter, and has a house and a bank account and an IRA and has one adult child with no grandchildren, a will can cover that scenario very nicely. Beneficiary designations are used to direct all the assets directly to the adult child. There's no risk of those assets ending up with minors, which is always a concern, to make sure that those minors are going to have the assets managed appropriately. But a will handles that scenario. When there are minors, you have to have a trust to direct those assets. If the distribution is a little bit more complex, you really want a trust to direct those assets.
Gotcha.
Boy, time flies, doesn't it?
It certainly does. It's been wonderful having you, Jessica.
Thank you so much.
And Jessica's going to come back. We're going to pick up with this topic in a part 2. So we'll talk about, what are the key things, the most important things we need to do to plan for when we age, as we age. With that, another episode of Elder Talk. Until next week, take care.
You've been listening to Elder Talk with TuckerAllen, providing intelligent answers for those thinking about their future, with Attorney-CPA Joe Cordell. Sponsored by TuckerAllen, your estate and elder law advisors. For more information, visit TuckerAllen.com. Listen again next Saturday for another edition of Elder Talk with TuckerAllen. The choice of a lawyer is an important decision and should not be based solely on advertisements.